Hi, everyone. Harry here to talk about the hearing in Judge Tanya Chutkan's courtroom, which just concluded on the subject of how to move forward in the long wake at this point of the Supreme Court's immunity opinion. All right, the sort of headline here is the parties acted as expected. DOJ is saying, let's try to do this as efficiently and methodically as possible, and in particular, so that there is only one more appeal in the case. In other words, Chutkan would decide all the immunity issues, immunity being the topic that has this special feature that permits the defendant to have an immediate appeal rather than going to trial. Trump asking for a protracted schedule and wanting to do all these other things, including receive discovery and tee up other motions, all clearly at the service of not having even a DOJ brief about immunity emerge before the November election. And Chutkan, understandably challenged and even vexed by the crypticness of some of the Supreme Court statements that it falls to her to have to interpret. At one point, a lawyer says, that such and such a statement is clear, maybe even intending a joke, but whether or not he intended it, the Trump lawyer, laughter breaks out in the courtroom. It's well understood that she's been given an assignment that is near impossible. One other thing is clearly understood by her and the rest. There will be another appeal in this case. She says, we all know there's going to be another appeal in this case. And at the end, somewhat forlornly says, because of that, it would be an exercise in futility even to set a court date. Nevertheless, she makes clear that she needs to go ahead. The parties do with immunity, but there are other motions they can do simultaneously. We can walk and chew gum at the same time, says Chutkan. All right. Those are the parties' basic positions. Let me double back and put a little bit more flesh on the bones of today's argument. So she comes right out. There's a little bit of sort of jocular back and forth. You look well rested, Mr. Lauro, that kind of colloquy. And then she gets down to business. I want to talk immunity and I want to talk schedule going forward. And the Trump team comes out pursuant to the schedule that they had given in the Friday brief, wanting to do all these other things. And DOJ is insisting, no, it's immunity, it's immunity, it's immunity. And Chutkan at one point says, look, we know there's going to be another appeal here. And if you just think about that statement, I've talked a lot about the implications of Smith's inclusion of the Mike Pence allegations in the superseding indictment, why it's so important. And she was totally on top of it. As she puts it, recall, in immunity, there's core powers that the Supreme Court says is the total immunity, nothing to be done about. Total unofficial acts, no immunity, just go forward. And this broad middle ground that are considered presumptively immune, but the prosecution can overcome that presumption by showing that use of the evidence would not undermine the function of the executive branch. She goes to the Pence evidence and says, I have to decide whether the presumption is overcome. And there's discussion about how that will be done. She says, very intriguingly to me, I don't think I can just do that myself. I would risk reversal. And that at least opens the door to, it may be that in her mind, she's thinking she actually needs to hear from Pence on the stand, which would be a seismic event. He would testify to the things Trump told him and the like. But that would be a big move, and I think it was just a stray statement that doesn't suggest that yet, especially because she said, I may need some briefing on that, a factual brief, to be sure, she says, but a brief on that would, one interpretation, I think, maybe until we have more indication. The better interpretation is that it would be about the facts as alleged in the indictment. In other words, it would not portend Pence's taking the stand. All right, as there's the back and forth and they keep pushing, Trump's lawyer finally lets the 900-pound gorilla out and says, we are talking about very sensitive matters because the election is coming up. And he says sensitive not just to Mr. Trump or President Trump, as they insist on calling him, but the whole nation. And Chutkan pushes back hard and sharply. She says, I'm not thinking about the presidential election. I'm thinking about a 4-count indictment. And that has been her mantra from the start. And to the extent there was some suggestion that maybe she would say, okay, let's just put this all over until the election so there's no question. I don't see that happening. I think she's going to schedule in the normal course of proceedings and have them. The DOJ said they actually walked back a little from the statement in the Friday brief that we are ready to go now. And what the lawyer, Thomas Wyndham, said to her is, we still do have to write the thing, but we can do it within 2 to 3 weeks. Okay, so that suggests something like the following. I think Trump's efforts to make this about everything except immunity, she will not accept, and she wants to keep her eye on that ball. In fact, she wants to keep her eye on that ball to the exclusion of even setting a broader schedule because everyone knows there's going to be another appeal. And I think she will accept the DOJ's argument that it's only sensible to try to do all the immunity at once. So the hope would be only one appeal and not back and forth, and this case gets tried in 2030. However, the fact that they're already accepting that single appeal says to me, and this is what I surmised at the time, that in including the Pence evidence, Jack Smith is ready for a fight, knows he's going to get a fight. That's a time-consuming fight, and that he is basically acknowledging that this trial will not happen until 2026, something like that. So that, in a sense, could be the headline that everyone understands we've got another round of appeals going, and the goal of the DOJ and Chutkan is to keep it at that rather than bouncing back up and down. All right. The other thing that was prominent in the hearing is Trump's lawyers really going straight to the heart of the Pence evidence and saying the new grand jury that superseded the indictment here heard Pence evidence, which was immune. They think that's their strongest argument for immunity. I do too. But based on that, they say the whole indictment and the whole case has to be dismissed. Chutkan was not very warm to that argument. I think she sees her marching orders from the Supreme Court as figuring out everything about immunity, allegation by allegation, paragraph by paragraph in the indictment. And she sees that, understandably, as a very hard task that's in front of her. A few other things about the hearing. First, Trump waived an appearance at arraignment here, which is something a defendant has a right to hear the charges and acknowledge that she or he understands them and enter a plea. So it's clear that unlike the first time around, he wants to avoid everything about this trial. He doesn't think it's in his advantage to show up, have chaos, try to use it to raise money. He understands now that where this trial comes up, it is more likely to hurt him. And the DOJ agreed he doesn't have to show up. But so his lawyer on his behalf said he understands the arguments or the allegations in the superseding indictment, and he pleads not guilty. Those are constitutional requirements, but he didn't have to do it in person. There's also a tussle about the indictment itself, in which his lawyers say this is a whole new case. We need discovery. We need everything before we can even start to answer on immunity. The DOJ says there's no new discovery to give them. And Chutkan pretty much shuts that down, saying, look, it's a slimmed down case. There is less, not more. Nevertheless, the fact that the Trump folks were making this argument, to me, suggests the wisdom of what Jack Smith did in getting a whole grand jury to bless the new indictment and return it, because you can be sure, had he not, that whatever the indictment said or did, even if it just excised words, and of course it did a lot more than that, it basically represented the allegations as coming from Trump, the candidate, rather than Trump, the former president, tried to make every argument that things are unofficial. You can be sure that had they not had a new grand jury, the argument would have been this is an improper superseding indictment, because they didn't just, less is more is fine for a superseding indictment. Adding things that a grand jury hasn't blessed are different, and you can be sure that that's what they would have encountered had Smith not had the foresight to take this to a whole new grand jury. So that is the main point here. Chutkan says, everybody says, immunity is the linchpin. Trump is trying to get her to zero in on Pence first and only, saying we think the indictment should be dismissed just because the grand jury heard Pence testimony. DOJ says we can overcome the presumption on Pence. We want to give you a brief showing that. And she seems to think, does Chutkan, that may be necessary. So the hearing ended inconclusively. She has to take all this advice back and figure out how to go forward, and not all the way to trial. That would be futile, she says. I mean, she's really been dealt a rough hand here. Forget about, pro-Trump, anti-Trump, whatever. Some of the instruction or guidance from the Supreme Court is completely Delphic. And, it will look, no judge likes to be reversed, but she's sort of being set up for a potential reversal, whichever way she goes, certainly to the extent she goes against Trump. And her statement that everyone expects another appeal, if you think about it for a second, makes clear that is going to happen, because there wouldn't be an appeal. Likely there would not be an appeal, or what she's thinking of, unless Trump, who has the right, went forward. If she actually says you can't use the Pence stuff, etc., it's very possible that the DOJ would conclude, well, if she says no, and we're not going to have a better shot at either the Court of Appeals or, of course, the U.S. Supreme Court. So in saying there's going to be another round, I think it's kind of understood that some of her rulings are going to go against Trump. No surprise, given how aggressive Trump has been to try to A, put this off, and B, combine it with all other stuff. Okay, so let me give the three bottom lines here. One, so complicated that there's not even a trial date to be set. Two, the DOJ, and probably to be joined by Chutkan, seek the goal of resolving everything on immunity at once, so there's at least a good shot of only one more trip up and down the federal courts, which does translate into, I'd say, a year anyway, into a 2026 trial. And then finally, in terms of the evidence there, Pence. There's a lot of stuff that's clearly unofficial. There's some stuff that's official based on what the Supreme Court said that the DOJ has taken out of the brief, things involving, the DOJ has, but it's things involving Trump's communications with the DOJ. But then what's been left in, and the third bottom line point, I said that this was going to be on TV. This was going to be a battle royale, and I think that's substantiated now. Pence, Trump trying to use it to dismiss the whole thing, the DOJ recognizing that's where they really have to go first and make the argument that the presumption of immunity is overcome, and at least without further indication on the papers and on the allegations, as opposed to Mike Pence on the stand raising his right hand. But her one comment is a little cryptic there, and we want to watch that carefully because, man, that would be a big event. There you have it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.